this honorable court.
Thank you. You may be seated. We have one case on the schedule this morning, case number 23-2251, AFSCME Florida Council 79 versus Public Employees Relations Commission. Appellant's counsel, when you're ready.
May it please the court, Matthew Blumen for Appellant AFSCME Florida Council 79, and I would like to reserve 5 minutes of my time for rebuttal, please.
Noted, thank you.
Thank you. The foundational issue in this case is straightforward. AFSCME Council 79, a labor union, applied to renew its annual license on July 31st of the year 2023. In that application, AFSCME included all of the information required under the licensure statute at the time. That would be section 447.305. And it paid the required $15 fee. However, the appellee, the Public Employees Relations Commission, who is charged with reviewing these licensure applications, denied AFSCME's application on the ground that the application did not include information required by a version of the licensure statute that was not yet in effect on the date of denial.
Counsel, what if, I know we'll get to this later, but there was a later application that was accepted. Took them, by my count, nearly 3 months from the time of that application to the time it was accepted. So my question to you is, this was filed on July 31st.
Correct.
If PERC had taken until after October 1st of 2023 to decide this application, why would they have been, I assume you're going to say that they still would have had to go under the 2022 law.
Correct.
But what is it in the statute that would have required them to ignore what by then would be the current law?
2 responses to that, Your Honor, if you'll allow it. The first response would be that that's not what they did, right? So this court is here to review PERC's denial, which took place in August of 2023, which was well before the October 1st, 2023 effective date. So it's AFSCME's position that that was legal error, and therefore it's reversible legal error. To your question about what would have happened if it had waited, it's our position that the October 1st date is mentioned 2 times in Senate Bill 256 of 2023, which is the bill that amended Section 447.305. The first time it's mentioned is at the beginning, where it says effective October 1st, 2023, Section 447.305 Florida statutes is amended to read. And so it's our position that on July 31st and on August 5th, that effective date had not happened, and therefore the statute had not yet been amended. And so the statute spoke as of its prior version, as this court has said in Dewberry and many cases since, as the Florida Supreme Court has said in Dewberry in many cases since. However, later, there is a provision in the statute itself that says for applications for renewal on or after October 1st, 2023, and then it goes on to lay out the rest of the requirements that were added by Senate Bill 256 of 2023. So we think that reading the effective date together with the second mention of October 1st, 2023, the proper reading remains that it applied to the new information, the new requirements applied to applications that were filed on or after October 1st, 2023. Now, we know PERC's argument is that it applied to applications that were due on or after October 1st, 2023. And, both of those interpretations require looking at the language and trying to divine whether the legislature meant filed or due.
So I'm not saying it applies when I say this, but
Yes.
Isn't it true that in 2024 they changed it to make it clear that PERC's interpretation is the one that the legislature accepts now?
No, it's not true, Your Honor. It is true that Senate Bill 1746 of 2024 did amend 447.305, and it's also true that it referenced applications filed on or after July 1st of 2023, but it did not say in straightforward or really any terms what was to be done with applications otherwise that were filed subsequent to the effective date of the new statute. And interestingly, it refers to applications filed on or after July 1st, 2023, but of course, Senate Bill 256 of 2023 took effect on May 9th.
No, I'm not
Yeah.
saying of when it took effect, but it does change in subsection 3, that, let me see, there's certain documentation that must be required preceding the date upon which the current registration is scheduled to end, which tells me that they meant to say that the operative date was the date that the registration was scheduled to end, not when the application was made.
Well, I think it's hard to know what they meant, Your Honor, from the way that the statute was amended. It was not unambiguous, but as we argue in our briefs, I think this is actually a classic example of why the Florida Supreme Court has instructed that we look to the supremacy of text method so clearly when looking at the plain text of statutes. And so when we're here, I believe what we should be looking at in interpreting this provision is the version of 447.305 that was on the books prior to Senate Bill 256 of 2023, and then the language that was put in Senate Bill 256 of 2023. And what a subsequent legislature did, what it did or did not mean, the Third District Court of Appeals this year in State versus Croce has interpreted the supremacy of text method to mean that we should not look at subsequent legislatures clarifying or other subsequent amendments to prior statutes, and I think that's right and faithful to the plain text statutory
But
interpretation.
doesn't it kind of show that, I mean, I understand if it's to change, then you're absolutely right. If it was meant to change the 2023 statute, but is it another way to simply show that it is to clarify, but not just to clarify, but to show that that is a reasonable interpretation of the statute as of 2023?
I don't think so, Your Honor, because when the Third District in State versus Croce did away with the so-called recent controversy rule, which was when a legislature comes and amends to try and deal with a problem, a subsequent court decision or administrative interpretation, the court was saying, look, the supremacy of text method tells us that that's not the kind of thing we should be looking at. And to suggest to the notion that there's some distinction to a clarifying amendment versus a controversy resolving amendment, I think is a distinction without a difference when it comes to looking to what the Florida Supreme Court has said about the supremacy of text method. I'm not aware of any case that says that there's a distinction between resolving a recent controversy and clarifying a prior meaning. AFSCME's position is that if it comes from a subsequently passed statute, then it's essentially parole evidence that's not relevant to look at the 2023 Senate Bill 256 or the prior version that was in effect at the time.
Can I ask you about mootness?
Yes, Your Honor.
You've gotten a new license a little later potentially than you wanted, but you got it. So what remedy can we give you even if we agree with you on the interpretation?
Thank you for the question, Your Honor. The consequences of PERC's actions to the question of mootness continue to be felt by AFSCME Council 79 and the public employees who have the constitutional right to collective bargaining who've lost their exclusive representative to this day. And I think in thinking through that question, it's important to look at the difference between 447.305 before and after Senate Bill 256. Before, approval of these applications was essentially a ministerial act, and it came with the consequence, but it was a very straightforward consequence, which was the inability to participate in a representation election to become the union of a new bargaining unit. After Senate Bill 256, there were essentially a whole new host. I mean, obviously there's the new information required, but there's also a whole new host of consequences. And those consequences depend on the membership rate in the bargaining unit and the union's subsequent organizing efforts within that unit. And so when Council 79 filed its July 31st, 2023 application for renewal, it had to list all 58 of the bargaining units for which Council 79 was the exclusive union representative at the time. For 6 of those units, Council 79 reported membership rates above 60%. So those 6 units were, Council 79 was automatically recertified as the union representing those units. But for 18 more units where AFSCME Council 79 reported under 60% membership, Council 79 was able to go out and do what SB 256 says needs to be done after October 1st, 2023, to avoid decertification, and that was to gather fresh showing of interest, desire to be represented by Council 79, member cards, showing of interest cards, not membership cards, from the members of those 18 bargaining units. Council 79 did that, and so there were 18 recertification elections that needed to take place. Well, Your Honor, not all of those elections have yet taken place. 14 of them have, but there are still 4 units from Council 79's application for registration that was granted, which have still not had these representation elections, where their status as the bargaining agent is going to be called into question, and where Council 79 is going to have to pay a statutory fee in the event.
And I understand what
Yes,
you're
Your
saying, but the license is, or the registration is for a year, right?
Yes, Your Honor.
And then the statute is effective October of '23. So even notwithstanding that, wouldn't you still be under the new law now?
I don't think so, Your Honor. I think that this court's decision in Lavernia, and I am sensitive to my time, and I want to address the court's desire to talk about jurisdiction as well. But in Lavernia, this court recognized a fairness exception to the general rule involving licensure, which is that if a license is denied during the pendency of an application, you go back and review it under the licensing law that comes into effect. And that fairness exception is exactly for situations like this, where it's not that the agency denied it and DOA said, look at some different facts. It's where there was a clear legal error below. And we cite the 3 cases referenced in Lavernia in our briefs, but one of them is particularly on point, or rather 2 of them. One involved an unreasonable delay, and we would argue that the delay in this case is patently unreasonable because it was an error of law. But the other, which involved a midwives licensing scheme, which was Department of Health and Rehabilitation Services versus Petty Eifert, which can be found at 443 Southern 2nd 266. It's a 1983 decision of this court, the 1st District, was on all fours because in that case, this court determined that the Department of Health and Rehabilitation Services had made a legal error in denying midwives licenses. Everybody agreed that there was an intervening statute under which the midwifery license applicants would not have qualified for a midwives license, but nevertheless, this court sent that case back and said the midwives licenses should be evaluated under the law that was in effect before the statutory amendment. That is extraordinarily similar to the facts before this court right now. Because
that was an annual license?
I don't know the answer to that question, but
that's fairly important, isn't it? Because what I hear you saying is the remedy you seek is one that we tell PERC that they're going to evaluate your application perhaps sometime in 2025 based on a 2022 law that's twice been changed, and that's procedural. It's procedural law, and that's going to take you into 2026.
Well,
based on the 2022 law that's not there anymore.
2 points, Your Honor. The first is that although it's procedural, it affects substantive rights, specifically the right to collective bargaining, and the presumption against retroactivity and the need for effective dates to speak by their own terms is clearly applies in this case, notwithstanding the fact that it's a procedural mechanism at place, and the Florida Supreme Court's cases are clear on that. But I would argue further that the fact it's an annual license actually makes this lower stakes for this court to send back. Imagine, if you would, that a midwives license was forever, right? Then you'd be sending this case back to have a healthcare provider given a license to practice that was contrary to law for time immaterial. Here, AFSCME Council 79 has no choice but to comply with this law. It is complying with it. It will continue to comply with it. Granting it the year that the legislature intended by delaying the effective date merely gives AFSCME the ability to get its affairs in order for a year on those membership rates, on the showing of interest cards, to avoid the decertifications, of which there were more than 30, and recertification elections, which it was subjected to because of PERC's legal error. So actually, I think the fact it's a one-year license argues in favor of remand to apply the law in effect at the time, not to the contrary. And I see that I'm down to a minute and a half, so if the court would like me to address jurisdiction, I'd be happy to, or I can wait till I come back.
We'll give each side an additional 2 minutes.
Thank you, Your Honor. So on the point with respect to jurisdiction, and of course, it's hard to know exactly what the court was thinking in asking the parties to address it, but looking to Article 5, Section 4, the district courts of appeal have power of direct review over administrative action as prescribed by general law. Here, that general law is the Public Employees Relations Act. I think it's clearly a general law under this Florida Supreme Court's decision in Florida-Grown with respect, which deals with medical marijuana licensure. And so then the question is, what do we do with 447.504? And that refers back to review final orders of the commission pursuant to Section 120.68, which is the Administrative Procedures Act. This was clearly a final order. It's captioned final order. It finally denied the registration.
Is it a final order if it sounded to me like a dismiss without prejudice, refile it. The order said refile your application.
It said to refile it, but it was a final order and it had final consequences, Your Honor. And I think here the question of jurisdiction.
Isn't that kind of the point of a dismissal without prejudice? In say a civil action, is that you have the chance to refile?
In a civil action, if you had the opportunity to refile under the same law and there weren't a retroactivity problem, then sure. But the reason this was a final order is because it came with final consequences. More than 30 bargaining units representing tens of thousands of public servants in this state have been decertified. And that involves state and local employees. AFSCME, just to give an example involving the city of Jacksonville, was decertified as the bargaining representative of the city of Jacksonville. AFSCME went out subsequent to decertification, gathered signatures from 30% of the employees of the city in that bargaining unit, which is more than 1,700 employees in that bargaining unit, and just 2 weeks ago was finally recertified after winning an election as the bargaining representative of those city of Jacksonville employees. That was a tremendous effort by AFSCME, fighting uphill against the consequences of PERC's legal error.
It was decertified as of what, the November date?
It was
January date?
It was decertified as of January 22nd of 2024. So the renewal was granted January 18th, and then 4 days later, AFSCME was decertified as the representative.
So you were decertified after the registration was actually approved?
Correct, because of the way the statute works, AFSCME had not gathered the 30% of signatures on the truncated, compressed time frame that PERC erroneously applied in a clear error of law. We didn't get the 30% of signatures for Jacksonville, so we were decertified, went out, organized, got those cards, filed, and just had an election and were certified as of October 10th of 2024, less than 2 weeks ago. And so that's the kind of uphill battle that the union has been forced to fight because of this unfair denial of its application in July 31st. And if I could just make one final point, because I see I'm out of time, is that when the union filed that application on July 31st, and Judge, this goes to your point regarding about July 31st and October 1st and the filing of the application, PERC's past practice was crystal clear, and in fact it had been applied to other AFSCME affiliates, that early registrations, and we give examples of them throughout our brief, AFSCME Local 199 is a good one, had filed more than 3 months in advance of its renewal date and been granted registration 4 days later. This was what AFSCME was accustomed to. And so when Senate Bill 256...
I guess going back to, I think, the first
Yeah.
question, the first example you gave us there, it took them 4 months to approve it. So here we would be talking about November or something like that, at which point there's a new regime in place.
In this case, it took 4 months, but in many other cases, including AFSCME Local 199,
Well,
which
I'm
is
talking about the first one that is in your, the first one, I think.
Oh, the
page 7 of your
firefighters
initial-
example.
The
And
firefighters.
indeed, there were instances of delay, and part of the reason...
Well, I think the second example was 1.5 months. So this idea of ministerial, I don't know what ministerial is in that kind of context.
Well, sometimes, and PERC's counsel may be able to speak to this, but sometimes PERC will review an application and find a deficiency, and certainly much more before Senate Bill 256 of 2023. If they found a deficiency on the face, they would send it back to the union to correct it, and that can take time. But in AFSCME's experience where we've come forward with correct and complete information, it is a ministerial act for PERC prior to Senate Bill 256 of 2023, to review the application, see whether the required information is there, has the fee been filed, and then to stamp it approved like they did with AFSCME Local 199. So all AFSCME did here was rely on the past practice and the guidebook that PERC had published telling unions to file at least 15 days in advance of the date of revocation. Not exactly 15 or within 15, but at least 15, and I'm just quoting from Appellee's brief on that point. So I do see that I'm out of time. I want to be respectful to the court. Thank you.
Let's add 3 minutes for the rebuttal, and that's probably means we add 4 minutes or so for appellees. Or additional minutes. That's probably 7. Did I give 3 first and then 4 more? So
You
for
gave 2 and
I
then
can't
3,
do
right?
math.
So
Right, the
5,
calculator,
but then he went
15
over.
plus 4.
I trust your math on
Yes,
that.
yes. Maybe give him 21 minutes. I think that's about
Sounds
right.
fair.
Sounds right.
That's right.
Sorry about that. The math can be hard.
May it please the court, Greg Morton on the behalf of the Public Employees Relations Commission. Joining me at council's table are Alyssa Lathrop and Tamara St. Hilaire from the commission. Happy to answer questions in the order you've got them, but I'll start with the jurisdiction since that had come up fairly recently. The order that the court issued asked us to look at the Constitution and provision of 447504. I agree with counsel that gives you the right to hear orders that have been appealed under general law. 447504 talks about final orders and appeals from final orders, but it references 12068, which talks about final agency action. And so I think that there is a possibility here that you could look at what PERC did on August 3rd and say, well, that was a preliminary order. We denied that license without prejudice to file a new application, regardless of the fact that I concede that we labeled it a final order and put appellate notice of rights in that order. Part of that, I think, was, though, that, and I don't think counsel views it opposing counsel views it this way, but we were trying to do the appellant a favor by saying, hey, you're too early here. Come back when your license has truly expired and file your new application. And of course, I'll cite this case for you. It's not in any of the briefing, but 57 Southern 3rd 869, that's a Florida First DCA case, Wade versus DCF. And it talks about the court is the one that's in charge of determining its jurisdiction, labeling something a final order or including a notice of final rights, even if both parties agree, is not necessarily something that controls the court's determination of jurisdiction.
Well, and the current version and the 23 version, but not the 22 version of 4473055 kind of talks about an incomplete application. In paren 5 there, an incomplete application must be dismissed if the required notice and documentation are not provided within 10 days of the organization receiving such notice. But PERC didn't use that procedure there with this order, right?
Correct, and it's this is a very unique licensing scheme because we have registrations and certifications, which opposing counsel talked about. That provision on an incomplete application talks just about census data, which is the 60% dues paying members, and that goes to how they report their certifications in our statute. We also are under 12060, so there are some incomplete applications where we're issuing standard deficiency letters like any other agency would, but we did not rely on that provision. That's correct.
Was it PERC's practice under the old law to just take applications whenever anybody wanted to file them 6 months early? I mean, I read the statute shall be renewed annually, and it sounds like you'll do it biannually. I don't know, maybe you'll do it quarterly. What's the disconnect there, given that the statute says shall be renewed annually?
And I think that that's an excellent question. And part of what we're doing, and we've been living with it for the past year, is implementing SB 256. So much of the case law that they've cited in their brief, that talks about PERC's decisions applied under pre-SB 256 case law, where the registration requirement was much more ministerial.
Well, I'm reading from the prior law.
Yeah, correct. And so the only penalty for not having that annual registration was you couldn't participate in an election, couldn't become a certified bargaining agent. So we have situations where they would lapse, people would file early, and we would grant them. When SB 256 was passed and became effective on the governor's signature May 9th, the registration scheme totally changed, in that the parties were required to do membership authorization forms, and there was a tiered implementation so that folks could get ready for this. So when opposing counsel talks about being surprised by this, they certainly didn't have to know what the legislation was going to pass, but once it was signed into law, they knew as of May 9th that they were going to have to do this. They knew when their registration was set to expire in October. Very briefly, it's a very brief record because of this being a preliminary order, but on pages 9 and 10 of the record, there's letters where they're talking about that they realize the impact of the law, not PERC's decision, but the law and the
Well,
requirements.
they
that
may
they're
have
gonna-
been aware that the law was going to change, but I would imagine that that's specifically why they put in the application early. It doesn't seem nefarious at all to take action before a law becomes effective in order to have an earlier law apply. I've seen that kind of thing a lot. And it seems to me that's what the union here was trying to do.
Well, I think Judge Winokur.
And there's nothing in the statute that prohibits it,
Yeah.
from what I see.
Yeah, and I think, Judge Winokur, that goes to your point about the timing and the chronology of all this. In the initial brief, all the decisions on retroactivity that are cited are general retroactivity decisions. In Florida, we operate under a different rule for licensure statutes, which is you don't backdate which law applies to the date the application comes in, and that's the EJ case and several of the other ones that we've cited in our brief. So the fact that they filed that application in July does not control which law applies. You noted that it took us 3 months to grant the application they filed in October. The year before, in 2022, it took a month for us to grant that application. So depending on the level of review that we need to do, the complication of the application, a number of different factors could enter into that and could delay it. The cases that they've relied on, talking about situations where the agency did something wrong or delay, I think the opposing counsel uses the term delay, are not applicable here because we did not delay. We, in fact, acted on it early and said, hey, this is premature, you need to come back because your license does not expire until October.
But I mean, my driver's license doesn't expire until 25, but I could go and renew it right now, right? I mean, so the fact that it expires, what does that have any bearing in the statute as it existed at the time the application was put in place on when you can apply for renewal?
That's correct. However, then that would get into some of our arguments on, well, what is the remedy? We're here.
Well, I mean, I understand mootness, but, and I guess we could look at mootness first or we could look at the law first. But in talking about the law as opposed to mootness, kind of in accord with what Judge Winokur was asking, if the, FWC puts in place, as of October 1, you have to have a hunter safety course to get or renew a hunting license. And I go and renew my hunting license on September 30th, I don't think FWC could say you got to have the hunter safety course to renew your license, right? So I mean, it seems to me that's kind of what you're doing here.
I would disagree only in that this SB 256 was a tiered law that had different stages of implementation. So as of May 9th, the entire law was in place, and it came into effect at different points in time. So,
But the licensing part was effective or the registration part rather, was effective October 1, right, of '23.
For licenses that expired, or for any license that expired after October 1.
What is it
yes.
about the text of SB 256 that supports that interpretation? That it applied to licenses that expired after October 1 instead of applications filed after October 1?
And I agree that there's some ambiguity in the statute. I think that our interpretation and of the statutory text is correct, that it was for registrations that expired after October 1st. And without getting too far into the weeds on the recent controversy rule, because I've read that decision and see where the court's coming from, but SB 1746 clearly embraced PERC's interpretation of how the law is appropriately read and demonstrates that was the legislature's intent, not just because of the adding the language that you referenced, Judge Whitaker, but they removed in SB 1746 the audit requirement and backdated the audit requirement to any application that was filed July 1st or after. Well, if October 1st was the controlling date for that, then anyone that filed their application before that would have not been filing an audit with that application as well. So I think that supports our reading of the statute as only applying to registration that were set to expire after October 1st. So if their registration had expired before October 1st, yes, we would have granted it under the old statutory law. Under the new law, because their registration now expires after October 1st, they were had to comply with those requirements.
And I cut you off when you were going to talk about mootness. Could we direct you to that and see what
Yes.
your response is on that issue?
Yeah, I know that we'd briefed this in a motion, and then your order denying it, you asked us to, or said that we could address it again. We're now October 1st, 2024. We've gone through an entire renewal cycle of registrations. Under any, if we had granted the application on the day that they had filed it, which never happens, because there's always some built-in review, we would now be in a position where their license expired and they would be required to file all the additional requirements as well. And also, they've got their license that expires,
Well, I mean,
registration that expires January 1st.
that's all true, and I don't think the union is denying that. They are claiming an exception to mootness, which I presume means that they, I don't want to speak for appellants in this case, but that they agree that it's moot, but that an exception applies. And it seems that the argument is pretty simple. If you apply the 2022 statute, there are matters that they were not required to comply with. And if you apply that, which is what their argument is, and if you apply the 2023 statute, there's an enormous amount of consequences that they have had to comply with that they wouldn't have to if you applied it. So in that respect, it's not, the mootness doctrine does not keep this appeal from going forward. Can you speak to that? To the extent that I disagree in that gets into the exception that talks about collateral consequences of the decision. And this is where PERC's registration and certification scheme are very unique. The registration is an annual registration that to represent these different unions with different employers around the state, you have to have a registration, and then you get your certification. The collateral consequences that they're talking about are not due to PERC's decision on their license. It's due to their disagreement with the policy and the So the
new
application
requirements.
itself did not cause
Correct.
these consequences.
These are all collateral consequences of the policy that's in the statute and the new requirements that
Okay,
are laid
well,
out.
if the 2023, if, let's just say SB 256, if it applies, which is the reason why you rejected the application, if it applies, then they have to comply with all these other matters, correct?
Correct.
Okay, and so Is it just sort of maybe I should be asking appellant's counsel this, but is it just the broad idea that 256 applies to them in this situation that causes this? And it's not related directly to the application itself?
That may be a question for them to answer. However, I will also point out that there's a lot of water that's flowed under the bridge that is not before the court, and maybe this gets back to the jurisdictional point, which is if they thought that granting their application in January was conditional and that they had to comply with all these additional requirements that they knew about from May 9th when the law came into effect, they haven't appealed from any of those orders. They have not appealed from any of the orders where they won elections. They have not appealed from any of the orders where their license were revoked. None of that's in the record, but other than in their response to the motion and somewhat in their reply. But in my mind, they should have been challenging those decisions as well, and you would have a complete record. Because one of the things that's important under 447's statutory scheme is promoting harmonious relationships between employers and employees. Each of those certifications that they're talking about, whether they were able to get their 30% showing of interest and file a recert petition that's now going to election, deals with a different set of facts, a different employer, and none of that is before you here.
Well, what happens if we agree with them and say, PERC should have, for this license in July of 22, PERC should have used the 22 statute as it was written on July 22. What happens then?
I don't know that I'm prepared to answer that question because it would be very difficult to figure out how to unring all those different bells, because
I mean, the cost and the trouble that they've gone to, there's not a mechanism for them to recoup that, right?
I mean, I think that the court has the power to craft whatever remedy it wants, but yeah, I don't think that there would be a way for them to come back and recoup those costs.
So I mean, that's not a collateral consequence.
Correct. That's directly related to the statute.
Yeah. Okay. Thank you.
So you've got about 5 minutes left. Let me just check my notes really quick and make sure I've covered everything. I know that rulemaking was brought up as one of their arguments on their brief. I'll rely on our briefing on that, but just if there are no other questions, I think there's many paths to affirmance here between the jurisdictional issue that you all have identified as being potentially that this was a preliminary order, mootness. I believe that we're correct in our reading of the statute, which is buttressed by the SB 1746 the next year, even though we don't need to rely on the recent controversy rule or distinguish between whether it's a substantive change or just a procedural change. I think that our reading is correct. The lack of a meaningful remedy, I mean, we're now in I think Judge Osterhaus, you made the point that we're we would be going back and applying a law that was in place in 2022 and 2025 potentially, and it's a law that's been amended once, and this goes back to your point, Judge Bilbrey, how would we craft any sort of remedy? Well, which parts of that law should we apply? If we're applying the 2022 law, would they have to file their audit that the legislature then remove the next year? I'm assuming that there would just be a lot of difficult consequences that fall from that. So if there are no other questions, I'll sit down.
Thank you, counsel.
May it please the court, just a few quick points.
If we could set his clock to 3 minutes. Thank you.
Thank you, Your Honor. I just want to start with something that counsel for the commission said, and I'm quoting in argument. As of May 9th, the entire law was in effect. That was a statement that we heard today. So there's been effectively a concession that what the commission did in this instance was to look at a statute, Section 4 of which, Senate Bill 256 of 2023, said effective as of October 1st, 2023, 447.305 shall be amended to read. And nevertheless, the commission applied the October 1 and forward version when it denied AFSCME's application on August 5th. That is a clear error of law, and whether it could have waited 90 days or it didn't wait, it has committed an error of law by applying a statute before it took effect. And as a result of the court's order asking the parties to address jurisdiction, we took a close look at 120.68, the judicial review provision of the Administrative Procedures Act. And it's actually very interesting. It instructs that the district courts of appeal, and it uses mandatory language, shall remand a case for further proceedings. I'm looking at subsection 7. When it finds that, and it lists a number of mandatory instances of remand, one of which is that and then now I'm at 7E, the agency's exercise of discretion was inconsistent with officially stated agency policy or a prior agency practice. Well, we've established that the prior agency practice was to treat this as a ministerial act and grant the registrations. Didn't do that. And then 4, otherwise in violation of a statutory provision. So what the APA is saying is that when you find an error of law, it's mandatory that there be a remand. And elsewhere throughout 120.68, it's quite extraordinary how broad the provision is. It, at sub 2, allows this court to order such ancillary relief as the court finds necessary to redress the effects of official action wrongfully taken or withheld. So PERC withheld the license to which AFSCME was entitled under the law in effect at the time. And the direct consequence of withholding that license was the decertification of more than 30 collective bargaining units in this state, representing tens of thousands of employees, not to mention 18 elections, which the union was subjected to that it should not have been, 4 of which have not yet been held. So I want to go now quickly to the point about mootness, because I appreciate the question about whether the collateral consequences here are the result of SB 256 or the result of PERC's actions. They are quite clearly the result of PERC's actions. If PERC had granted the application on August 5th when it denied it, that would have given AFSCME an entire year to work with the members of those bargaining units to sign them up for membership and maybe get above the 60% automatic recertification threshold. Would have given them the ability to organize and sign up members of those units on showing of interest cards, maybe get them to 30% within a year, as opposed to within just a handful of months in order to avoid decertification. But AFSCME wasn't given that grace period that the legislature intended.
Correct me if the way I understand this is that subsection 6 of the new statute under Senate Bill 256.
Correct.
It's not really part of the application process per se. In other words, you've got subsection 3, which adds these requirements that have to be made for a valid application renewal for registration. Couldn't you just say that what PERC was saying is, look, you failed to do these things. You failed to have this A through E requirements in your application. And that the requirements of subsection 6 about the 60% and going through all that, those are consequences of the act itself and not a result of what they did. In other words, all they asked you to do was just comply with subsection 3.
Appreciate the question very much, Your Honor. The answer is no, because the way, and then PERC's counsel spoke to this a little bit, it is a unique licensure scheme. And the way that it works is that those requirements at 6 are only triggered 30 days following the expiration of a license. So they really go hand in hand, and I think PERC's counsel acknowledged this, right? So if AFSCME's July 31, 2023 application had been granted, then the expiration date of that license would have been kicked forward to July 31st of 2024, and that would have provided the year that AFSCME absolutely expected it was going to receive. And I just can't focus on that enough. PERC's counsel has been quite clear that the prior practice, and Judge Osterhaus asked this question, that the prior practice was when they received an application, there'd be a quick review, and if everything was there, they would just grant it as a ministerial act. Well, we did exactly what Judge Winokur acknowledged was not nefarious and in fact is quite common with heavily regulated entities. We took a look at this law, we got our ducks in a row, we crossed our T's, we dotted our I's, and we filed an acceptable application, including all of the required information, on July 31st, consistent with PERC's instructions, and expected that ministerial act to be granted. We prepared for compliance. It's not as if we think this law will never apply. Of course it will apply, but what the legislature intended by delaying the effective date was precisely that labor organizations would have a year to get from October, at least until after October 1st, enough time to get their affairs in order. And the absolute last thing I'll say, I know I'm out of time, is that it's also interesting to me that under 120.68, a number of the judicial review instructions to this court are about what to do with agency discretion, right? So if you look at sub 7 about doing something inconsistent with prior practice, there's a line in there that says, but the court shall not substitute its judgment for that of the agency on an issue of discretion. Well, the last time this was amended was 2016, but Florida's voters did something in 2018, and we speak to this in our brief, which is that they ratified Article 5, Section 21 of the Florida Constitution, which instructs that courts of review shall not accord deferential review or discretion to administrative agencies. If this court does not hold PERC accountable for the error of law here and says, well, this is moot, or we lack jurisdiction, or it's too hard to unscramble the egg, which it's not, because the application could be granted and we could go forward a year from now, then what would effectively be happening is that administrative agencies in the state of Florida would be accorded unfettered discretion to ignore the effective dates passed by the legislature and then just merely run out the clock. But Article 5, Section 21 stands for something. It stands for courts exercising independent judgment, and when the legislature says clearly a law has not yet taken effect, there has to be some mechanism to hold agencies accountable so that they don't just ignore the words of the legislature to the detriment of regulated parties like AFSCME.
Thank you, counsel.
Thank you.
We're adjourned.
All rise.